Want to know how the new Digital Competition Protection Bill is shaking up the tech giants? Hello, Namaskar. Welcome to MindSync's weekly Wednesday podcast, your compliance guide, where we dive into the world of compliance. As Wednesday arrives, so do we, with deep insights, engaging discussion, and a fresh perspective about compliance and law. India's Ministry of Corporate Affairs released the draft Digital Competition Bill on March 12, 2024, aiming to curb anti-competitive practices by large digital platforms. This bill is somewhat akin to the Digital Markets Act in the European Union and is designed to impose various obligations on what are termed systematically significant digital enterprises, or SSDEs. So what does this bill entail? For starters, it prohibits SSDs from engaging in several unfair practices. This includes self-preferencing, where platforms favor their own products over those of third-party vendors, and restricting third-party apps. It also targets anti-steering policies, data misuse, and product bundling. Essentially, it's a comprehensive framework to ensure a level playing field in the digital market. And let's face it, guys, well, we all know the drill. You search for a product online and suddenly all your social media feeds are bombed with ads for the same. Coincidence? Not really. This bill aims to put an end to such intrusive and unfair practices. One of the key features of the bill is the self-reporting requirement. Enterprises that met specific threshold must notify the Competition Commission of India about their status within 90 days. The proactive approach is a significant shift from the existing ex-post framework under the Competition Act of 2002, where the CCI intervenes after anti-competitive conduct has occurred. Now the CCI also has the authority to designate an enterprise as SSDE if it believes the enterprise holds significant power in the digital market. This includes factors like economic influence, market integration, user dependency, and more. If designated, these enterprises must comply with stringent obligations. Here's where it gets interesting. The obligations for SSDs are quite detailed. No self-preferencing means they can't favor their own products over those of the third parties. No restrictions on third-party apps. Employee users have the freedom to choose their preferred application, and anti-steering policies are a thing of the past. Business can now communicate freely with their end users. So picture this, imagine tech giants are like the one uncle at every Indian wedding who insists on being in all the photos and hogging the dance floor. Annoying, right? The bill is basically telling that uncle to take a seat and let everyone else have a chance to shine. So what if an SSD doesn't comply? The CCI has robust powers to conduct inquiries and impose penalties. Non-compliance can result in fines up to 1 lakh per day with a maximum of 10 crore. And if you think you can just ignore the CCI, think again. Failure to pay these fines can lead to imprisonment or hefty additional penalties. Interestingly, the bill also includes provisions for personal liability. If a contravention occurs, individuals in charge of a business can face penalties unless they can prove their experience, due diligence, or were unaware of the conduct. This adds a layer of accountability at the managerial level. In conclusion, the Digital Competition Protection Bill is a significant step towards fostering a fair and competitive digital market in India. It aims to prevent monopolistic practices and ensure that the digital economy thrives on innovation and consumer choice. Thanks for tuning into MindSync's podcast. If you found this episode informative, don't forget to subscribe for more updates on the world of compliance and advisory services. Until next time, stay compliant, stay informed.